Your Honor, on the notice of motion, paragraph 5, we are being told that the respondents resulted in widespread destruction of property. Widespread. Your Honor, you know that the standard of proof in any criminal matter should be proof beyond reasonable doubt and not proof on a balance of probability. And therefore, Your Honor, when we talk of widespread destruction of property, it means that the rule of specificity is not observed. Then they further go and tell you that there's looting of private property, and then they don't provide evidence to that, as at today, as at now. And they talk of that the respondents will pose a serious threat to public safety and national security. Your Honor, I will draw you to a case of R versus Richard David Aldens. That is the High Court at the High Court of Nairobi, criminal case number 48 of 2016, where the court denied a claim that an accused should be detained because the case was highly publicized, and therefore releasing the accused would cause a breach of peace and public order. Your Honor, the court held that the prosecution's claims were speculative and that it had not provided evidence demonstrating the unlikelihood of arrests. So therefore, Your Honor, in addition to that, there were no complaints made from the public. I draw you to your brother, Justice Wasame, as he then was, in R versus Munir Haron Ismail. That is criminal revision number 51 of 2009. And he said clearly, Your Honor, that the basic denominator is to secure attendance of the accused, in our case, the suspects, to answer to charges against him. Your Honor, in paragraph 6 of the notice of motion, we are told that during the arrests of the respondents, several items were recovered as exhibits. And Your Honor, clearly, they've not shown. We don't have the exhibits before you. We don't have an inventory before you. Even photographs, Your Honor, we don't have. So these are just mere statements of puff or mere averments. In paragraph 7, Your Honor, of the notice of motion, we are being told about the seriousness of the offense. Your Honor, that owing to the seriousness of the offenses, the risk to public security and national security implications. Your Honor, the suspects you are seeing before you, vis-a-vis the police, Your Honor, the state has monopoly of violence and has all the tools of violence. Your Honor, if you see in some of the videos on social media how the state, how the police is executing the young ladies, the future of this nation, and men, young ladies and men, Your Honor, your heart will bleed And if they are doing that to the unarmed civilians, what about those who will go to the police station armed? They can bomb them, Your Honor. Paragraph 8 of the notice of motion, Your Honor, we are being told about the complexity of the investigations, and that this includes recording of witness statements. If I had my brother, the inspector, he stated clearly that the witnesses went to the station, and at the same time, he's yet to record their statements. And Your Honor, the suspects before you have been held beyond 24 hours, from 7th to 9th. So therefore, Your Honor, when you look at the cases that are presented before you that they will be charged with, that robbery with violence, and you slightly go deeper into the elements of these charges, robbery with violence, you see, and he agreed that he did say that he found the suspects in flagrante delicto, red-handed. So that means that, Your Honor, if he was to carry out forensic analysis of what? If you look at the elements of that crime, which entails that they are found in a group, found with weapons, they must have been violent, and the element of robbery established. So you are being told that they need more time to carry out forensic analysis, Your Honor. Another case is the assault of a police officer, Your Honor, and we are not told of the OB number of the said case, not here as we speak, and at the same time, the names of these officers, not told. And Your Honor, we are also not told of any P3 form that has been filled. Then, Your Honor, as I finish, when I come to paragraph 6 of the affidavit, Your Honor, paragraph 5, sorry, that at the time of the arrest, the respondents were duly informed of the reasons of their arrest, which is good enough. And Your Honor, by the time you are being informed of the reason of your arrest, it means that the IO is ready to charge you. So which means that the investigation is complete and therefore charge. But it comes before you, Your Honor, persuade the court that I've arrested the suspects, give me more time. I've even held them beyond the 24-hour rule. I still need 10 more days so that I can continue investigating. By the time they were informing them, the natural laws of justice dictates that you arrest, you investigate, then you arrest. Not arrest, then investigate. Paragraph 6, Your Honor, I'm almost finishing. Paragraph 6, you are told that the respondents herein are believed to be part of a group of approximately 1,500 individuals. Believed to be part of a demonstration turned violent outside Georgia Police Station. Your Honor, this is hearsay evidence, which is not and should not be admitted in this competent court. And Your Honor, the IO did not tell us that he's an expert in matters statistics or mathematics. That when he looks at a video, he knows that these are 1,500 people. Even myself, Your Honor, a certified actuary, having scored first-class honors, which is mathematics, pure mathematics. Your Honor, I cannot look at a video and say, these are even 40 people, leave alone 1,500. As I finish, Your Honor, paragraph 17 of the affidavit. You are being told, Your Honor, that the respondents pose a high flight risk. And I will draw you Your Honor, we are being told that the respondents are a high flight risk. And there is no evidence given. He just says that we do not know where they are coming from. Your Honor, they do not have to know where they come from or where they stay, so long as the respondents attend court religiously and spiritedly. And Your Honor, be that as it may, the respondents have identification documents which they can leave before you, Your Honor, where they can be found. And that can help you, can help the IO, to trace them. And Your Honor, these are not foreigners, these are Kenyans, law-abiding Kenyans who are enjoying their rights to demonstrate. Your Honor, you are also being told that the seriousness of the offenses, and that I will give you the case of Richard, again, R versus Richard David Alden. And it was stated clearly that even a capital offense does not constitute a compelling reason. Even a capital offense does not constitute a compelling reason. And in the case for flight risk, Your Honor, I just give you that case, I'm sorry. In Job Kenyanya Musini versus the Republic versus Job Kenyanya Musoni, High Court at Nairobi, criminal application number 399 of 2012. The court allowed a bail application and held that mere allegations that the accused was a flight risk did not suffice. The prosecution ought to have substantiated its claims. And there is no proof that they even have passports. So therefore, Your Honor, as I finish, the definition of compelling reason as per the Thesaurus and Oxford Dictionary is that it has to be something so grieving, so strong, so convincing, and so undeniable. Hence, Your Honor, Article 49(1)H states that an arrested person has a right to be released on bail or bond unless there are compelling reasons. Yet the reasons that were being given by the prosecution are uncompelling frivolous, and fickle. Therefore, Your Honor, Article 37 protects the respondents to enjoy their right to peaceably demonstrate, picket, and present petitions. Article 21 further states that it is a fundamental duty of state and every state organ to observe, respect, protect, promote, and fulfill the rights and fundamental freedoms in the Bill of Rights. And therefore, the respondents should enjoy their right to liberty, which is enshrined in the Constitution, and not granting them the bail, Your Honor, is infringing on their right to liberty and may amount to miscarriage of justice. Rest my case.